The next matter to come before the court this morning is State of Ohio versus Brian J. Adams. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. For the appellant, you wish to reserve any time for rebuttal. If you let me know when you get started, I'm keeping the clock this morning and keep you apprised of the passage of time. You've read the briefs and we are ready to proceed when you are. And Russell, if you could use this.
Use this podium.
Yes, thank you.
Never had a multiple podium situation before. May it please the court, my name is Attorney Joseph F. Salzgeber on behalf of the defendant appellant Brian J. Adams. I would ask to reserve the balance of my time. I do not expect to take the full 15 minutes. This case involves a challenge to the imposition of post-release control against Brian J. Adams. Back on July 26, 2007, Mr. Adams pled guilty to a 5-count indictment. He was sentenced by Judge Ewers to a total of 7 years in prison. In his original entry, there was no indication of what would happen if he violated post-release control. The consequences were not stated. Subsequently, there was nunc-pro-tunc to include the aggregate sentence of 7 years. That nunc-pro-tunc entry did not include any mention of post-release control at all. Mr. Adams was subsequently released after serving a full 7 years on August 3rd, 2013, and then there was an attempt by the authorities to impose post-release control upon him. He filed a motion in June of 2014 through the Public Defender's Office to vacate or void post-release control. That was denied by the court, and this appeal was taken from the denial of that motion. In this particular matter, I think that the law is rather clear in this case, that the failure of the court to indicate in the judgment entry consequences for violating post-release control, and then in the second nunc-pro-tunc entry, failing to even mention post-release control at all, constitutes a violation which would require the vacating of his post-release control sentence. This court has repeatedly ruled, based upon the Supreme Court precedent, that both the period of post-release control and possible violation sanctions must be included in the judgment entry journalized by the trial court. And that's this court's decision in State v. Gooden in 2011, State v. LaShore also in 2011, and then citing directly the Supreme Court case of State v. Singleton from 2009. State v. Lang from 2011 out of the Ohio Supreme Court also supports the conclusions of this court that, in fact, if the court fails to impose the statutorily mandated post-release control as part of the sentence, that sentence is void and must be set aside. I recognize that the statute allows for corrections, however, that's only before the conclusion of the prison sentence, and in this case, my client concluded his prison sentence before post-release control, before there could be any effort to correct that.
I see in the sentencing that was quoted, it says the defendant was advised at the time of the plea of guilty no contest, the post-release control, and the consequences of violating the terms. Well, are we going to find in the record the transcript of the hearing that says what was not said, what you're saying was not said at the time?
Well, it has to appear in the judgment entry, Your Honors. That is the crux here. It's not stated in the...
The statute says that.
That's what the law requires. I would reserve the balance of my time and ask that this court vacate post-release control with respect to my client, Brian J. Adams, since he served his sentence and post-release control was not correctly imposed.
Good morning, Your Honors. Mary Slanska on behalf of Appellee of the State of Ohio. The state has never, and did not in our brief, put forth that the trial court acted correctly in not advising Mr. Adams about the consequences of violating his sentence. What the court said, which was has been a recurring issue with motions to vacate sentences and whatnot, was the trial court said that the defendant was advised of the consequences of violating any term of post-release control. This is not the typical case that we look at where the issue is that the court failed to advise some of post-release control. The trial court in the journal and in the original sentencing entry did advise Mr. Adams that post-release control was mandatory for 5 years. So he was on notice. He knew that he was going to be on post-release control. The only issue
That was at the
original sentencing hearing. The court then, at some point later, puts on a nunc-pro-tunc entry. And the basis of the nunc-pro-tunc entry is it wasn't clear what the total aggregate sentence was. And although it's not in the record, what I'm guessing it typically happens is the Ohio Department of Rehabilitation and Corrections says, hey, in calculating the sentence, we're not sure what the total aggregate sentence is. The court puts on this nunc-pro-tunc entry. And there's a lot of case law that says the court doesn't have to go back and re-advise and do a whole new sentencing hearing, especially because this is a 2007 sentencing, which was after the July 2006 cutoff between whether you had to have a new sentencing hearing or you could simply do a nunc-pro-tunc. This fell within the nunc-pro-tunc. The trial court, although not correcting post-release control, issued that nunc-pro-tunc entry and did not restate that Mr. Adams was on post-release control. But there's a lot of case law, and I've cited in my brief, that says you don't have to, that the nunc-pro-tunc entry doesn't have to be a complete entry. It doesn't have to state all of the terms. In other words, the court can, it's limited to correcting the error that it's talking about correcting.
Counsel,
Yes.
what of the law that says you have to have in the sentencing entry the consequences of violating post-release control, not the nunc-pro-tunc? Let's go back to the original. I think State versus Ketterer in 2010 said it's got to be in the entry. And I think that's part of the argument.
Right, and our problem here is that that case from 2010 was long after Mr. Adams had been sentenced. He was sentenced in 2007, and there was no appeal taken from that. And that, I think, is part of, and what the court will recall from the record in this case is that this is a delayed appeal of that June 2014 entry. In other words, there wasn't even a timely appeal after that motion to vacate based on case law that had come out after the fact. There was no appeal of the sentence at that time. And in this case, the other problem that complicates this issue is, Judge Schaefer, something that you had touched upon, which is that there's no transcript from the sentencing hearing. We're simply talking about that sentencing entry. And this may very well be a case in which the trial court could issue a nunc-pro-tunc to correct that at the sentencing hearing if we had a transcript of that. I'm not representing, because I haven't seen it, I don't know, because it wasn't part of the record. But at the sentencing hearing, the trial court very well could have said, if you violate post-release control, you will serve 1 year in prison. And you know, without knowing that did or did not happen, I think that it's really not proper to have a delayed appeal in this case when you have no transcript of that hearing. You know, the court had said that they would that was a preliminary ruling that the court might change based on argument, and the state's position is that this really is an appeal that shouldn't have been allowed from this because it's from a 2007 entry, and it's yet a further delay from a June 2014 motion saying, I want to vacate a sentence from 7 years previously. The history of this case, I think, speaks to the fact that this could have been raised in 2010. We wouldn't be here today, and perhaps there would be a more complete record, or Mr. Adams would still be in prison, would have still been in prison at that time, and the court could have simply corrected it with a nunc-pro-tunc entry if it had been raised at that time, and it never was.
Well, this is not a post-conviction relief.
No, it was a motion to vacate the void sentence. But I would submit that I believe that if the trial court properly advised, well, let me stop there. I'm going down my point I want to make. If Mr. Adams had even filed this motion back in 2010 when this case came out. But what he did was he waited until he was on the brink of getting out of jail so that the court would not have the opportunity. And I'm not, it may not even be an intentional, but that's the way it's worked out in this case to the prejudice of the state. Because the state submits that the court could have, if it had properly advised him that he would serve 1 year, in other words, the consequences for violating post-release control, that the court could have corrected it to say, I want the entry to reflect what I actually said at the time, which is you get 1 year. So even though it's not post-release control, what I'm arguing is that this is like those post-release control cases in that while Mr. Adams was in prison, this was something that the court could have corrected with a non-proton, or even in the worst case scenario, a new sentencing entry at that time. And then to allow Mr. Adams to wait until he is now out of prison. He got released, as counsel noted, in August of 2013, and then we have this motion. And, to allow him to do that is the prejudice to the state. And I think that that's part of the reason that it's kind of unfair to allow a delayed appeal in this case, because where do we stop and go back and say we're not going to allow this? These post-conviction motions that put the state in a position that they can't go forward on something that was a viable means to them to correct the mistake that we're talking about here. I would ask that the court deny the leave to appeal, and in the alternative to deny the motion based on the fact that there is no transcript from the sentencing hearing in the record. And I think that the case law is clear that really the court needs that to fully consider the arguments that are raised before the court today. And if there are no questions.
Thank you. In response to the argument that the state is somehow prejudiced, the state had a chance to do this and correct it on the non-proton entry. They failed to do so. The law is clear that my client can challenge his sentence on a collateral motion and collateral appeal such as this. So the state is merely arguing that it wants another crack at Mr. Adams, even though he's already served his complete sentence. And the law is very clear. Once he's served his sentence, the court cannot go back and correct that sentence to add the post-release control. We would ask that this court vacate that portion of the sentence now that Mr. Adams has served his full 7-year prison term and conclude this matter on that basis. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on the Hot Supreme Court website. Thank you.